Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our two-weekly community conference call that we've been holding for the last almost 20 years. Today is June 10th, 2021. Let me just make sure you can all hear me.
The conference is now in conversation mode.
I'm just doing a sound check. You can hear me? Everybody okay? All right.
We can hear you, sir.
Thank you. Thank you very
Yes,
much.
we can hear you.
Thank you.
The conference is now in presentation mode.
So I'm logged into our forums.immigration.com, and I'm looking at the posted questions. There were about 12 or 13 posted questions. I've told the team to cut the questions off at 12 or 13 because otherwise I have no time to really follow up and talk with people, and maybe we'll have time remaining for new questions. I'm going to read the questions that I have marked as frequently asked questions first. There are a lot of frequently asked questions today. And then I will invite your input if you have any questions related to what I've discussed, and we will go on to the next one and next one, so forth. With that said, let us get started. The first question is mother's green card, and there are birth certificate issues. So they're planning to file for their mother a green card. She was born in 1949 in India, and she does not have a birth certificate. Only identity with date of birth she has in her is her passport and her Aadhaar card. Is it required for her to submit birth certificate or a non-availability of birth certificate for I-485? So the answer is yes and maybe not. Does she need a birth certificate? Sure. But if she doesn't have a birth certificate, you should get 2 affidavits from people who were alive when she was born. They don't have to be adults. They have to be alive when she was born, and get secondary evidence that you can. Along with that, if a certificate of non-availability can be obtained, that's great. If not, the State Department maintains a list of unavailable documents by country. You might have to do some Google search on that, but there is a list of documents that are unavailable, and birth certificates from India, I think before 1970 or 72, are deemed to be unavailable. So if you provide a screenshot of that along with 2 affidavits from people who were born or who were alive when she was born, that should cover you. One interesting question is, does USCIS accept birth certificate from Indian consulate in New York? And I've had some mixed responses from my own colleagues. Personally, we never use that because I think it's bad evidence. It isn't solid as what we are suggesting. But I have colleagues who swear that they were able to use that and the government accepted birth certificates from the consulate. So why don't you do everything? Go ahead, get a certificate of non-availability if possible, get a certificate, a birth certificate from New York, get 2 affidavits from people who were alive when she was born, submit all of that together. So cover everything, do the shotgun approach. Please press *5 on your phone if you have a follow-up question. No new questions, any follow-up questions on this, please. *5. Okay. So the next one is a situation, another frequently asked question that comes up quite frequently, where somebody has H-1B extension, they're trying to get beyond 6 years, they are outside USA for 1 year, remainder option. So basically, let me explain to you generically how it works. So let's say you've been in the United States for 4 years. Then you leave the USA for 1 year. At this point, you have 2 options. You can come back to the United States for 2 more years, which is remaining from your original 6 years. Or you can, because you've been outside for 1 year, reset and get all 6 years of H-1B. You are allowed to do that. Being outside the United States resets both the H-1 and the L-1 so that you have the entire 6 years or 7 years again. Okay, 6 in case of H1B, 7 in case of L1. But here is the catch. If you come back for 6 years, then you have to go through the quota again, the H1B quota. L1 of course has no issue, but you have to go through the quota again. However, if you choose to take only the 2 years that were remaining from your original case, you don't have to come through the quota. You do not. That's called the remainder option. I'm taking the remainder of my H1. With that said, let's look at this case. I stayed in USA for 5 years, went back to India. After 1 year, my employer filed and lottery got selected in 2020, got my visa stamped in 2021 with the validity till 2023. So you did not take the remainder option. You chose the entire 6 years. Okay, I got my visa stamped in April 2021. Because of new location and salary mismatch. I'm not sure what this means. Are you on the phone? Press *5 if you are here. Press *5 because I'm not clear about this question. Okay, so let's unmute you. Hi, where are you calling from? Area code 401?
Yeah. I'm calling from India. My friend, she connected the conference call for me.
Okay. So I don't understand this. You said your employer filed a new application through lottery.
I will explain.
Okay. Go ahead.
Yes. After a gap of 1 year, my employer filed in H1B and it picked up in lottery.
Right.
It was for the Milwaukee location, but for the same client, they changed the location to Atlanta region.
Okay.
And they filed the amendment.
Okay.
But when the amendment came, they had given validity for 9 months only.
Okay.
And when our internal immigration team contacted USCIS,
now stop. I got it. Sir, I got it. Stop. Okay. So what has happened is USCIS has made a mistake. They should give you entire 6 years. So your H1 should be approved for 3 years, not for 9 months. Okay. So your lawyer should reach out to them and say, look, we haven't asked for the remainder option. We actually went through the lottery again. Give us our 3 years. I'm entitled to it. Okay. No worries. They should give you 3 years. All right. Sir?
Okay.
Yeah. So they have made a mistake.
So what is the status for the new H1B?
You can use it to come in and then get an extension, no problem.
Okay. Yeah, that is what they are suggesting, that you travel. And will file extension for 6 years.
Absolutely.
But there was a confusion.
Yeah. They are just, what USCIS has done is, they did not realize that you went through the lottery again. So they gave you just the remainder of 9 months, the remainder option, which is okay. Come on in and they have to correct it. It's your right to get it corrected. All right.
Okay.
Good luck, sir.
So my new H1B is still valid, right?
Yes, sir. It is. I have to move on. Okay. Good luck. Area code 614. Do you have a follow-up question on this? Area code 614. Okay. I'll remind you one more time. We are not doing new questions. We'll only do that at the end of the session if we have time. But I'm answering all the questions that have been posted and any follow-up questions to that. No new questions. Next frequently asked question. So this is another question that people ask me a lot actually. I'll come to INA section 203G later, but one of the most commonly asked questions is this. So I have a priority date that came up this coming month. Okay. What if I don't file my 485 in that 1 month? Will I lose my priority date? Will I lose my green card? And the answer is no. You simply have to wait till the next time the priority date becomes current again. The priority date may become current it may come and be gone 50 times. You don't lose your priority date. You simply lost your right to file 485 until the next time the priority date becomes current. One thing I want you to watch out for, sometimes it is required that you file a 485 if you want to get H-1B extension beyond 6 years on a 3-yearly basis. You must be able to explain why you did not file the 485. But that's a minor problem as compared to the worry that you're going to lose your priority date. You will not. Okay? So with that, let's go into the questions. My I-140 is with employer A. Employer B has not started green card process yet. I'm outside the US. My date became current recently. I'm concerned that I have just 1 year to file 485 or lose my priority date forever. INA 203G applies to consulates. Okay, so think about it this way. You are applying through consular processing, not 485, consular processing. Your file has been moved to the consulate and you have received, after going through everything else, National Visa Center and all of that, your file has gotten to the consulate in New Delhi, for example. And the consulate sent you an interview notice and you did not appear and you did not do anything on the case for 1 year. Your case will be considered abandoned. That has nothing to do with 485. Okay, so it does not apply to you. Can I get cap exempt H-1B if I-140 is revoked? Will I be on 1 or 3 year term? So this question has multiple components. One component I already discussed with you. If you want to keep getting 3-year H-1 extensions, one of the questions asked is, why did you not file your I-485? And you have to have an explanation for it. In your case, the new employer has not yet started your green card. You cannot file 485. And also you're outside the United States. So I think you should be entitled to 3-year H-1B extensions going forward. Now the next question. If my I-140 is revoked, what happens? Well, if you're talking about question 1, that doesn't apply to you, so that question doesn't mean anything. You appear to be fine. There was a second set of questions, maybe from the same person, or maybe from another person. This one says, I have worked in the United States from 2005 to 2012, got an I-140. I had to relocate to India. Can I file 485 once I come back to US? Yes, but only if the job through which you got your I-140 is still available. If you go to a different employer, you can carry your priority date if the I-140 was not revoked, and you have to start the green card all over again. But the priority date will be the same. Okay. And there's no 203G? Yeah, 203G application here either, as I have already explained. So there is a hand up already from area code 617. I remind everyone that I'm only taking follow-up questions on this issue I discussed. Nothing new, okay? So let's go to area code 617. 617, are you from Boston?
No, I'm actually from India. I have connected using Google Meet.
All right. Tell me, how can I help you?
So my question is, if you said if my priority date passes, I can reapply again, right?
Yes. Whenever your date becomes, one second, sir, 1 second. I want to clarify that let's say that your priority date is current in July, but then it slips back in August. You have to wait until the date becomes current again.
Yeah, so I didn't understand that concept.
I'm going to explain that. I'm going to explain that. Give me 1 second.
Yeah.
So your priority date was current in July. In August, it slipped back again, because they do that, right? They keep going up and down, right? You don't understand that? That happens all the time. Priority date is current this month, it's gone away next month. That's how it works. So priority dates don't always take.
Yeah, I was not aware.
Yeah. So it's possible, let's say that you have a priority date of 2007, it was current in July, but it went back again to in August, it slipped back again. It's no longer current. Let's say in November it becomes current again. Then you can file. But if you don't file then you have to wait until it becomes current. Okay?
Yeah, and do you have any idea how frequently this becomes? Say if I have the example of October 2007, if I do miss it, will it be coming back in some short duration?
We will need to consult an astrologer for that. Okay? Because I can't predict that for you. So, but it doesn't cause you any permanent damage. That's what I'm trying to say. Okay?
Okay. Thank you.
You're welcome. Good luck. Okay. Let's go on to the next. Again, frequently asked questions first. So this one is, how do you maintain your green card if you are taking long trips outside the United States? So I want to clarify a couple of things here. Okay. First of all, if you have a green card and you leave the United States with intention never to come back, you pack your bags, you resign your job, you sever all ties and you leave. You want to come back 3 days later thinking, well, you know what, I don't like it in India or Italy or France, wherever I'm from, I'm going to go back. Technically, your green card is gone. Why? Because you left the United States without an intention to come back or with an intention not to come back. So technically, your green card can be taken away at that point of time. Another situation is where people, especially parents, think that they can come for 2-3 months every year and maintain their green card. Not true. The green card requires that you live in the United States. You can visit India, but you can't live in India and visit United States and keep your green card. Your green card can be picked up at any time. With those principles in mind, let's go to the question. They couldn't go back to India till October. They came to India in October 2019. Did not have a re-entry permit. Will not be able to fly until July end. I worked in the US till 2017 for 17 years. Last 2-3 trips were short. I have my savings 401k. See, the problem is if you have been outside the United States for 1 year, you have lost your green card technically. But I was mentioning this in the last conference call also we did. I said there was an interesting guidance from Customs and Border Protection to airlines that let people board even if they have been outside USA for more than 1 year as long as their green card is not expired. So what does that suggest to me? That suggests to me is that USCIS or CBP, to be more precise, wants to be flexible, and if people got stuck outside because of COVID-19 and no fault of their own, their green card should not be harmed. So far, there is no concerted policy beyond what I have seen transactionally. I have never seen any statement from the government that expressly says so, that we are going to give great latitude to people who have been outside for COVID-19. You can, of course, file an SB1. That's always an option. Okay. You can definitely try booking a ticket directly. And if the airline says, no, you can't board the plane, you can actually download the instructions from Customs and Border Protection to airlines that say, let them board if they have an unexpired green card. My wife and my daughter are US citizens. If I lose my green card, will I be able to apply for family-based green card? Absolutely. This is done all the time. Just make sure whatever you tell the government in every application you file, including SB1, you are meticulously honest. Because if you tell a lie, you'll be barred forever from coming to the United States. But if you tell the truth and something goes wrong, most they can do is take away your green card and you can apply through a 21-year-old daughter or through a US citizen wife right away. Within a year and a half, you should get your green card again. Okay, so those were all your questions. Press *5 if you have a follow-up question. Press *5. Okay, this one is from, I guess its number is Virginia, but they are calling from India, I guess. Virginia, go ahead.
I'm calling from Virginia.
Yes, ma'am.
Thank you, sir. Thank you so much.
My pleasure.
I came one more time last year for my mother who has a green card. This question related to the expiring of green card. She was able to come in October during COVID, maintain her green card status, but her green card is expiring this year at December 2021. She's still here, and I want to file her green card here.
Yes.
So just one quick question, sir. When I file her green card, it's before 6 months, so I think I'll be eligible at the end of this month.
Right.
That will be exact 6 months.
Okay.
And then I have to do her biometrics here, sir. So is that an option to do it here, and how long will she have to wait because she wants to leave now?
Okay, 1 second. So let me try to understand. Your concern is not with filing the application. You know you can file the application. Your concern is
Online, yes.
Your concern is biometrics, whether she needs to be in the United States for the biometrics. Is that what you're asking?
Yes, yes.
Okay, so look, I have not filed a form, what is it, I-90 something, for a very long time. Our team does that.
Okay.
I don't know exactly what the requirements are, but when you have a biometrics involved in the process, such as re-entry permit or green card renewal, you can request the government to expedite that. Okay? And we've had it expedited in 5 weeks. So we've had biometrics for similar procedures done within 5 weeks after we filed the application. It does not hurt to ask them.
Okay.
Okay?
Perfect.
Good luck.
And there's a separate letter for the request? To request this?
You should, what you should do is, you should put a cover, like a different colored sheet on the top, like a red colored sheet or a pink colored sheet, and say request expedited biometrics. And after you have filed and you've got your receipt number, you can also call them.
Okay. All right. Thank you so much.
You're welcome.
Thank you.
Good luck. Okay. Next one is California. California, go ahead please, 408.
Yes, sir. This is about the family-based green card. I mean, this is a follow-up question. As I requested that information that if I lose the green card, would I be able to apply for the family-based now?
Yes.
Will there be any conflict, like if I already had? Yeah.
No, there's no conflict because you had a green card and it was abandoned. So that green card no longer exists. You are entitled to a green card, no problem at all. Okay.
Okay. And generally, how long does it take?
I don't want to guess that. There are too many variables. I would say between a year to 2 years, year and 2 years, something like that.
Oh, year to 2 years. Oh, okay, sir.
Okay.
Okay. Thank you very much.
Good luck, sir. Okay. So then the next one is, did we cover this? Yes. The next one is number 6. Advance parole, H-1B, visa ban, national interest exception from India, travel restrictions from India. Okay, there's a lot going on here. Let's see what's going on. I hold an H-1B visa and also an approved advance parole. Am I exempted from travel restrictions? The following guidance was from an embassy in India. The presidential proclamation only restricts non-immigrant travel. And advance parole is not a non-immigrant. That's a very interesting question. I am not sure I have an answer for you. And you were right, because this has never been clarified. So you have a genuine dilemma. What should you do? What you should do is contact Customs and Border Protection. Why? Because ultimately they are the ones who allow you to enter or not enter. Okay. If CBP says, yes, you can travel, and that advance parole is not covered by a non-immigrant visa ban, you should be okay. Personally, I don't know if this is correct. Okay. The way I read it is, and again, I could be wrong about this, but the way I would analyze this is, unless you are covered by an exception, you cannot come. And the exception is only available to the enumerated categories. However, USCIS and the Customs Protection CBP might be looking at it differently. Best thing to do, contact CBP. Okay. *5 if you have a follow-up question on this. *5. This has never been clarified. I can make that very clear on the record. Never been clarified. Okay. Next question. So visa stamping in a third country, TCN, third country nationals. What does that mean? I am on an H-1B. I went to India and I find that the Indian consulate is not issuing visas. Can I go to Malaysia or any other country where visas are open and go to the US consulate there? The answer is yes, you can. This is allowed. Not only is this allowed, and I mentioned this earlier in another conference call, I think it was with UD or it was maybe in our last conference call. I said that the State Department has said you can get TCN done, but because of the COVID-19 backups, make sure the consulate you go to is going to process TCN cases, third country national cases. I know Mexico is still doing that because lots of our people have gone and gotten their visas in Mexico. So technically you could go to any country and get a visa stamp. So the question here is from Geeta. She's in a doctoral program, starts in fall 2021, currently on a B2 visa and in the US due to a family exigency. I don't want to go back to India. Can I go to another country? And the answer is you can go to Mexico, but here is the problem with student and tourist visas. This problem does not exist in H-1B or L-1 visas, but for J-1, F-1, and tourist visas, sometimes, not always, sometimes the consulate can say, look, we would like to issue you the visa, but only your own consulates can judge whether you are a risk of 214B here, you will stay here forever illegally. Only your own consulates can do that. I personally think it's worth a shot. Okay. I can't think of any reason why you shouldn't try. Of course, the problem is, would you be allowed to come back on a tourist visa? If you're denied entry, denied your visa in Mexico, your guess is as good as mine. But it is worth taking a chance. That's the way I feel about it. *5 if you have a follow-up question. *5. Okay. Question number 8. Filing multiple I-485s primary and derivative. So the question is, if there is a husband and there is a wife, they both have their green cards going independently, is it a good idea to file 4 I-485s for the couple? And the answer is, it is no longer necessary. Because for the past few years, USCIS has been converting primary to derivative and derivative to primary, even if there are only 2 I-485s filed. To take an example, let's say in the first case, wife is primary, husband is derivative. They file 1 485. Wife is main, husband is derivative. Let's say husband filed his I-140 and got it approved. The normal policy is, if husband's priority date becomes current, they will automatically convert husband's 485 from derivative to primary and wife's from primary to derivative. It's very weird. They normally don't make these kind of accommodations, but for 485s, they have been doing that. Is there anything wrong with filing 4? There is nothing wrong with it. I have done it sometimes. The only thing I make sure is that the A numbers match. As long as they match, I don't see any reason why you shouldn't file 4. *5 if you have a follow-up question on this. *5. So I have a follow-up question from area code 682. I'm not sure what this is in reference to. 682, where are you calling from? Hello, 682?
Actually, I was having a question for the previous questions follow-up, but I just got a little late and you started a new question. It was about visa stamping in a third country.
Why don't you go ahead and finish that up anyway?
Okay, so my case is a little similar, but not completely. So I am right now on F1 OPT, but my wife is here on a tourist visa, on a B2, and she's here almost like for 4 months now, and her like one term stay is left for 49 days. So she can stay until July 29th, and not after that for one term. So I wanted to know if I could apply for her F2 dependent yet or not, because what I have studied online is like you should apply for 45 days beforehand, and also if she's in US for 4 months.
Wait. All that is not really, they don't really follow that rule. The rule that they do follow has two components. All of them are allied with misrepresentation. So, when did your wife obtain her visa, her tourist visa? Was it before getting married to you or after getting married to you?
It was before getting married to me.
How long before getting married to you? 1 month, 2 months, 1 year, 2 years?
No, it's been years, like I guess 4 to 5 years.
Good. Has she been to the United States multiple times?
Yes, she has been here 2-3 times.
Okay.
Like in 2015 or 16, she has been here
on
a tourist visa.
Were you then married or no?
No, I was not married, and she came with her family, not me.
Okay. So this time, when she came to the United States, at the airport, they would have asked her the purpose of her visit. What did she say?
Yes.
What did she say?
She said because her brother is her brother is also here. He lives in Penn State. So, and I was also with her when she came with me only. Because I was also in India, and we got married, and I came here with her. So she told the consulate that her brother is here and I am here, and she's just coming to set me up.
Wonderful.
And meet her brother as
Wonderful.
well, and stay for some time.
Wonderful. I like this case for a change of status from B2 to F2. Why? Because she made full disclosures. She didn't hide it. She says, look, my wonderful husband is here and my beautiful brother is here. I'm coming to visit and set them up. And there was a genuine reason for it. And then now she wants to convert to an F2. It was not a decision she had made when she came. Okay. Her mind changed after 4 months. Did she come with a two-way ticket? Normally you do, right?
Yes. No, it was a one-way ticket, not a two-way ticket. So the thing was, when we came here, we planned that she'll go back in 2 months.
Good.
But because of COVID and all, we thought like we can stay here, and it became 4 months now.
Good. So that was the first rule, the rule about misrepresentation. The second rule is, nobody should apply for a change of status within 90 days after entry. So that time is gone. I don't see any reason why you should not file her F2, sir. Okay. I see no reason. Go for it.
Okay.
Okay.
I'm sorry, your voice broke. Can you repeat again? I'm so sorry.
I said go for it. I don't see any reason not to.
Yes. So Rajivji, just one more thing. Great. Thank you so much for that. But just one more thing is like, this is my 1 year of F1 OPT is already gone. Okay. And I have applied for F1 OPT extension, STEM extension.
Right.
But I have not received my card yet.
That's okay.
So that doesn't matter in this
That
case,
does
right?
not matter.
I don't know.
Sir.
I just wanted to clarify.
That does not matter. You're still good to go. All right. I'm not sure if you heard me. I said you're good to go.
That does not matter until my status is valid.
Yes, sir. All right. Yeah, I think I'm going to have to go on.
And so I should hire an attorney like to process all this, because I don't know how
that's your call. I can't really, I would say that this is delicate enough to get yourself a lawyer.
So just one thing is like, should I do it with attorney or I can apply independently?
Okay.
I don't know how to provide
hang on, sir. In your case, it is...
Rajiv, your voice is breaking.
I'm
so sorry, but...
I think it's your line that's the problem. because you keep cutting off for me. Get a lawyer. That would be the better thing to do. Okay? I gotta go on. Get a lawyer if you can afford one. Get a lawyer. Okay? I gotta go. Okay. So I can't spend that much time, guys. I have a limit, unfortunately, in these calls. Next question is from Jordan. This is also a very commonly occurring problem. So what happens is, let's say you have an H1 and it's good for 3 years, and you go to Malaysia. You are from, or you're wherever, outside USA. When you're coming back, instead of giving you the remaining 2.5 years on your H1, the Customs and Border Protection gives you only 6 months or 5 months because your passport is expiring in 5 months. This can happen. What happens then? Well, you have to extend that H1, and you can do it one of the two ways. If you already have a visa stamp on your passport, you can travel out and come back, and you should get the remaining time because your passport is now renewed. And second is to apply for an H1 extension like you normally would, paying the USCIS fees, going to the USCIS like you would go for a transfer or for an amendment. Okay? So whenever you have a shortened I-94, either you travel outside USA and come back after passport renewal, or you apply for an extension. So the question is, they refuse to extend it. They normally won't. CBP won't extend it if it is because of passport. You can extend it by going out of the country, as I said, if you have a passport, if you have a visa stamp on your passport. Her EAD your wife's EAD is expiring in December. Can I apply to renew it before renewing the I-94? No. Go ahead and get your situation sorted out and then come and apply for her. You can apply for her extension. I don't see any problem with that. *5. If you have a follow-up question on this, press *5 on your phone. *5. Okay. Okay, these were all the frequently asked questions. Now we have some non-frequently asked questions, only 3 or 4. Let's do those first. So we had a lot of frequently asked questions this time. So visitor visa extension for parent with expired I-94. Oh wow, that's not good. Mother-in-law arrived in USA in Feb of last year. You applied for an extension for 6 months, Feb 4th, 2021, on June 19th, 2020. So you applied for her within time. Her first case is still status is still under processing, and the second extension is under correspondence was received. She's getting close to the end of her second extension, requested for 4 months. We would like to extend. Her authorized stay expired on August 18th. Can we apply for another extension for 6 months while her first and second extensions are in processing? Yes, you can. As long as you apply it within the time you have asked for in the second extension. Can she stay in the United States even after June 26th, first and second application requested date, while the application is being processed? Yes, she can. And I have actually written an article, a brief comment in the Economic Times on this. Will your visa be cancelled at the airport? I have an author page in the Economic Times. Just read that and you will see the complicated issue this presents. But yes, she can stay. Will it be considered overstay? That's where, it's not overstay, but they can sometimes use that to to decline her entry, and I think it's all wrong, and I'm hoping that they will get all this together, because the section of law under which they try to do it is not really applicable in these cases. So can she do it? Should she do it? Right now, health is more important. I don't think this extension and stay back is going to cause any permanent damage. That's the way I see it. How soon do we have to leave the US if declined? So if any of these cases is rejected, she should plan on leaving right away. There is no time limit, maybe a week, 10 days, whatever is reasonable. But once it's denied, unlawful presence begins. Any one of the 3 cases gets denied, she's got to leave. Staying beyond 1 year has any impact on future visits? And the answer is yes, because if she's lived here too long and she wants to come back again in 3 months, that's not going to be allowed. So once she leaves, let her stay out for at least 1 year before she comes back in. *5 if you have a follow-up question on this. *5. Okay. Area code 201. That's New Jersey. New Jersey, right? 201?
Yes.
Go ahead, ma'am.
Yes.
Go ahead.
Just last week, she has received her biometrics appointment for the first application.
Good.
So in that I see like she has her first and 2 receipts, but last week it felt like 2 days later of she getting her biometrics, we have filed for 3rd extension.
Good.
So in that case, should we be carrying all the 3?
Yeah, why not? It's not like you're carrying 3 sacks of potatoes. It's just 3 pieces of paper. Why not? Carry them all.
Okay, sure.
Okay.
Yeah, and also one last question. And she has like in all the I-94 and her first passport, and she has her name, like the first name as together, like in case if it's like Lakshmi Rajam or something like
right.
together, and in her second passport it is like she has a space in between.
Yeah, that's a long discussion. That's a long discussion. I won't have time for it right now, but suffice it to say, these kind of minor issues should not be a problem. Okay?
Okay.
Good luck. Okay, so next question. So applying under Computer Systems Analyst job title. I have a bachelor's in mechanical engineering. I'm a Canadian citizen. I have an MBA, 10 years of experience, TN under Computer Systems Analyst. I think if I remember correctly, you have to double check this, Joe, but if I remember this correctly, you have to have a degree in computer related field or a postgraduate diploma with 3 years experience. So unless you have a postgraduate diploma in technology, and I'm speaking from memory, I don't remember the exact requirements, you will not be able to come into the United States as a systems analyst. Also look into something else again, I don't remember off the top of my head. Will the government accept a degree/experience evaluation from a Canadian university as equivalent? I don't think they do experience, but they might be able to do education. But your degree is mechanical engineering. So I don't think it quite works for you. I could be wrong about this. I have to look at it. Some research has to be done. But I would look at these 2 angles. I would look at the angle on Schedule B of NAFTA. Well, now it's a different agreement. I would look at that and see, I think it is bachelor's degree or postgraduate diploma in technology with 3 years of experience. I don't think you would qualify under those. Can you somehow slip in your experience? I don't think you can, but it doesn't hurt to look into it. Okay. I don't have a whole lot more to say about it because some of this requires some more study. *5, if you have a follow-up question, maybe I can try to answer it. *5. Okay. This is from area code 902. 902, where are you calling from?
I'm from actually Canada.
Okay, sir. How can I help you?
Yeah, So I actually checked in the NAFTA drafting. So there are like two ways I can go in as a job title, either as a consultant or I can go in as a computer system analyst.
Yes.
And there is a degree is required, but they when I go to the computer system analyst, the job requirement, it doesn't say that you have to be a computer related, and I have some friends who got as well. So
okay, I have to. That's why I said we have to.
Only one question.
Right. Go ahead. Finish up.
So, only one question for me is like if let's say the computer system analyst job title has been rejected by the borders. Will I be able to change to a new title and go in?
Why not?
Will that be a problem?
Why not? We actually had somebody who was rejected as a technician, but they were allowed as a consultant. So, you can. As long as you're not lying about any component of your job, that should be perfectly okay. All right? Good luck.
Yeah, thanks, sir.
You're welcome. Okay, so, there are two more questions left. I don't think we have time for new questions, but let me finish these two. Noor Ahmad had a lot of problem with a lawyer. Can I sue the lawyer for financial and emotional damages? Lawsuits are a question of state law. So you have to talk to a lawyer who practices in the jurisdiction in which the case will be filed. I can't comment on that. Plus, it's not my field. 2, what options do I have to report to this lawyer? You can report him to the bar if you think they have done something that is unethical. And of course, if they tell you something and don't do it, mistakes will happen. Bar is not going to punish somebody for a mistake that was not the result of gross negligence. But if somebody is grossly negligent or they lie to you, the bar can be very tough on that. So you can complain to the bar. *5 if you have a follow-up question. I don't think you have any other question. *5 if you have a follow-up question. Okay. So the last question is EB-2 to EB-3 downgrade after filing I-485. I moved to a new employer in November 2019. They started reviewing my documents for perm prevailing wages now. I have an approved I-140 EB-2 with my previous employer. My priority date is June 2013. I'm planning to go back to my previous employer in October 2021. I might get a chance to downgrade to EB-3 and file I-485. I heard that if you stay with an employer more than 6 months from I-140 approval, that I-140 can't be revoked. That is correct, but only if the I-140 was pending or it stayed approved at least on or after January 17th, 2017. Anything revoked before that, you have no protection. But revocation after January 17th, 2017, when the new law came into picture, which keeps you safe even after revocation, that would help. They need 2-3 months to reactivate. So I guess they might have revoked it. They might have to refile it. There is no reactivation. They have to refile. They can refile, of course. Well, if they are going to refile the I-140, they might as well refile it as an EB-3 right now. Why refile it as an EB-2? I think that's the smart thing to do. Okay. You have any follow-up questions on this? *5? Yeah, I would just file an EB-3. But, I want you to review some of the frequently asked questions that I have addressed on downgrading. My concern is always when an employee leaves and comes back. I won't have time to go over all the nuances, but I have discussed them all in our frequently asked questions. Okay, let's see. We have a question from area code 973. 973, go ahead, please.
Thank you so much, Rajesh. My 140 with my previous employer has been approved in 2017 October, which is after the new law, right? So, and it was not revoked until I stepped out of that company.
Very
it
good.
Revoked after
so let's hang on. Let's hang on, ma'am, hang on. So let's establish two things. You are now protected forever. Your priority date is forever yours. And two, your ability to extend your H1 beyond 6 years is also protected. Just because they revoked the I-140, that cannot be revoked. So go on to the next one. Next question.
Okay, but if I go back, do they have to in case if I have to do it in EB2 category, do they have to again apply for EB2 because they told me that I don't have to?
No, they don't.
The labor process.
They don't. They don't. So what they can do is, if they are refiling the I-140, they should file it as an EB-3. Okay. Let them get the EB-3 approved. Let them file your 485. Somewhere along the line, if it looks like EB-2 is becoming advantageous, you can file again under EB-2 with the same PALM application. Okay. So you can upgrade also. All right.
Thank you.
You're welcome. Good luck. Okay, guys. I still have about 10 minutes. So *5. If you have any question, press *5. Let's see how many we can do. We're going to do a lightning round. Oh my God, there's 6 people. Oh, 7 people. Okay, so we're going to do a lightning round, only about a minute per person. Go quick, okay? Let's see if we can do them all. Area code 224. Area code 224. Go ahead, please.
224, is it?
Yes, sir.
Okay, so I'll try to take a little bit. Okay, basically I have a full-time employee. I'm a full-time employee. I didn't file my prom labor yet. So my question is, can my previous employer?
Yes, they can. Yes, they can.
Can they file concurrent employment?
Yes, they can.
I still want to maintain a full-time.
Yes, they can. So the question is, can I work for 2 employers on H1B? The answer is yes. They can do a concurrent H1B if they want.
Yeah, but 20 hours. I'm only planning to do 20 hours.
That's okay.
140.
That's okay. You have other issues. You have other issues. You should talk to your lawyers. Because remember, green card can be only for a full-time employment. And full-time means 35 hours or more. Now, also remember, green card is for a future job. So currently you could be working 20 hours, but when the green card comes, you can work 40 hours. So something like that can be established. Just make sure it's done honestly, and just make sure they have the ability to pay your wages. These are the 2 tricky issues. All right?
Okay, so temporarily 20 hours is okay, but once I get green card, full time.
That is exactly right. That is exactly right. All right.
Thank you so much.
You're welcome. Area code 720.
Hello, sir. Thanks for taking our question. My question is there a possibility that an exception will be made to the residency requirements to honor citizenship applications from permanent residents who have stayed outside the country for more than a year due to the pandemic?
There is a possibility, but so far we don't see any signs of it. Okay?
Okay.
Good luck.
Do you think, sir, is it a good idea to apply and submit all the documents?
For naturalization? Absolutely. Try it.
Yes, sir.
Try it. I don't think you'll get it because it's a statutory bar, but it doesn't hurt to try it. You would have lost your naturalization filing fees. Big deal. Try it. Okay.
Sure, sir. And there is no other drawback.
No, I want you to have a lawyer for this. This is not something I want you to do yourself. Let them review your case, make sure that there's no other damage being caused. But I think it's at least theoretically possible to do this. Okay?
Sure, sir. Thank you so much.
You're welcome. Area code 801. 801, go ahead please. 801.
Yes, hi Rajiv.
Hello.
So I had a question on I-485J. It says offer of employment rather than employment.
That's exactly what it is supposed to be. That's exactly what it's supposed to be.
Okay. So can I move from one offer of employment to another offer of employment without actually working for either of the employers?
Yes, you can. So let's say you filed your 485 with employer number 1, and at that point you had I-140 approved, 485 pending 180 days. You moved to employer 2, you worked there for 1 year, never filed supplement J. Then you moved to employer 3, worked there for 8 months, never filed supplement J. Then you moved to employer 4, now you want to file supplement J. Yeah, that's fine, no problem.
But let's say if I want to continue working at employer 3, but once I get my green card, then I'll work with employer 4. So is that fine or?
Well, that's fine. The only requirement is that when you file your supplement J and when you got your green card approval, it was your intention to stay with this employer indefinitely. If you have a preconceived intention to leave, it can be a problem. I have a lot of frequently asked questions on this. Your question will come under the category, I have my green card, how soon can I leave? Okay? Review some of those questions.
Okay.
Good luck.
Thank you.
You're welcome. Area code 410. Go ahead, please. 410.
Thank you, Rajivji. I'll respect everybody's time. So just a quick question is, with expired I-94 and expired visa, can I revalidate my visa by going to Mexico or Canada?
You have an expired I-94. Now the problem is, if your I-94 expires, and you are going to go for a visa stamping, right?
Visa revalidating.
Well, revalidation, there's no such thing. Visa revalidation used to be a procedure many years ago. Now you're just going for visa stamping. Can you go to Mexico? Yes, as long as you have not accrued unlawful presence. So as far as USA is concerned, you can go to any country to get your visa stamping.
Okay. So visa revalidation is no more.
There's no such thing. There's no such thing. It's just a new visa stamping. Okay.
Okay. All right. Thank you. I'll add the detailed question for the next session.
No problem. Good luck to you, sir. Thank you. Area code 813. Go ahead, please. 813.
Yeah, hello Rajivji.
Hello.
Thanks for taking our questions.
My pleasure.
I had a very common question. It's about the advanced parole. See, if I go to advanced parole and I come back and I enter on advanced parole instead of like on H1B, so I lose my H1B status?
No.
Is that the
No.
case?
The rule is, if you re-enter on advanced parole and take up the same job that you were doing on H1B before you left, you are still considered to be on H1B.
Okay. Because, I'm supposed to go to India to visit my family, but, the people are saying, no, don't do this. You might lose your H1B status.
No, you don't.
Green card gets rejected.
You don't.
Okay. So if I come back, someone said you need to file a new I-9 in order to retain your H1, regain your H1.
Don't listen to someone. Don't listen to someone. Just listen to your lawyers. Okay.
Okay.
Good luck.
Thank you so much.
Good luck.
You, appreciate
You're
it.
welcome.
Thank you.
Area code 847. Go ahead, please. 847. Area code 847.
Hello, Rajivji. My question is about the I-130 form. I got my green card, but I could not include one of my kids because he aged out and I had to move him to F1.
All right.
Now I want to file his I-130. Can I use my I-140 priority date on his I-130?
No, you cannot. Okay.
Okay.
You can't transfer it. Sorry. Okay. Area code 510. Go ahead, please. Oh, wow. We did all the questions.
Hello,
excellent.
Thanks for taking the call.
Yes, sir. Go ahead.
Hello.
I can hear you.
So thanks, usually for taking the call.
My pleasure, sir.
So my mom received the green card in March 2021. While submitting the green card, we opted for 944 the public charges, and also we also opted for exempt from public charge. So can she utilize the state funds or federal funds for the taxes, not taxes, the insurance payments, like in Washington Health Finder, which gives her for credits for her insurance?
I'm very weak on this for a bunch of reasons. Bunch of reasons. Why? Because these requirements of financial responsibility have been phased in and out so many times. Right now we are back to the old times before Trump came into the picture. So as to the particular benefits, what she can and cannot take, it would depend upon the nature of the benefit. I'll give you a simple rule. Okay. First of all, if there are only private funds and no government funds involved, there is no problem. Number one, like in unemployment insurance. Number two, if it is not a means-tested benefit, in other words, it is given to people based upon how much money they make, like food stamps, you have no problem. But anything else, that will need to be evaluated by a lawyer. And I would suggest you talk to a local lawyer in the state in which the benefits are being obtained. Why? Because immigration lawyers in those states might be more familiar with the program than we are. It'll take me only a couple of minutes to familiarize myself, but I would still not be as familiar as somebody who's been doing this day in, day out in that state. So if it is just Obamacare,
I just want to check if there is.
Yeah, we have gone back to easy times again. There was a time when they made it ridiculously difficult, and they try to keep out as many immigrants as they can, but we are no longer in that. So right now, the grounds of deportation or exclusion are, if I remember correctly, only two grounds, and this is on USCIS website. You can just Google public charge /site:/USCIS.gov. And when you get to public charge, it tells you there are only two reasons you can be excluded. One, you took cash assistance from the government. And two, you took long-term inpatient care, like for example, in an old people's home or some kind of a hospitalization based upon the government dime. There is no other way they can deport you. Okay, so that's what I do remember.
It's not about deport, sir. Just for the citizenship, will there be an issue with the citizenship?
Yeah, I don't want to comment on that because law is full of surprises. I would not want to comment without looking at the entire law and giving an opinion in my own satisfaction, which I know that I've looked at everything possible. I don't know the answer. I have to look at what benefit you are seeking. I have to look at what impact it could have on citizenship. If I were to make a very foolhardy, reckless guess, I would say, I don't think it's going to be a problem, but I don't want to say that without looking at it. So go to a local lawyer, ask them. If you're not satisfied, go ahead and reach out to me, send me an email. We'll give you a consultation and we'll charge you for the research. Of course, we'll let you know how much we are going to charge you before we do it. Okay?
Sure, sir. Thank you, sir.
Good luck, sir. Well, very good, guys. You too. I'm very pleased that we were able to do all the questions. Oh, there's one more left. Okay, we'll do this one more. I really have to go into another call. So we'll do one last question. For some reason, I don't show you. Can you put down your hand and put it up again? Press *5 and then *5 again. Thank you. Press *5 again. Oh, no. Actually, I think I already got that one. Okay, very good. Well, we'll see you again in 2 weeks. It's always a delight to be with you. Next Thursday, we'll talk again. Bye-bye.